Then on the Sarameta chair, I think this letter is very insultive. We are being insulted by Kapali here, and we must not take that lightly. No one is going to prescribe to us on how we must ask questions. This letter is prescriptive. They are telling us to ask this and not to ask that. We're going to ask questions which we think are relevant in the context of the terms of reference. And Chair, the legal team must have authority from us. They must reply to them, to those attorneys or lawyers, and tell them that we're going to ask questions which are relevant to the terms of reference. Of reference, and anything that they are telling us, we're not going to regard is it. And if that would make them not to appear, I mean, their client not to appear, so be it. Then that would mean we are going to have another a problem that we will have to deal with. It means we're going to have a person that we will have to summon for her to come and appear before us. So we must not agree, Chair, to these conditions. These are prescriptive conditions which are going to undermine the very same authority that we have as this committee. So we don't agree with this one in its entirety. It seeks to undermine and it seeks to continue with what Paul O'Sullivan has done to us. So we're not accepting this, Chair. The legal team must write and they must inform those legal representatives of SARA that there is no question which is relevant that we are not going to ask. Whether that question is related to a romantic relationship or not, if we think it is necessary to be asked from the witness, we are going to ask that question. Thank you very much.
Thank you, Chair.
Proceed, Honorable Sikhosana.
Yeah, indeed, Chair. I must say that we cannot be dictated here. You know, whether those what you call it, WhatsApp messages have been taken away or been redacted from us, that doesn't matter. We are going to ask questions which we think are relevant. No attorney, no firm of attorney will dictate to us how to question the witness, Chair. It never happened anyway. You know, if that's the case, then they must go to court and tell the court that they don't want their client to be questioned. This is Parliament, Chair, and we've got term of reference, and we know what we are talking about here. I'm not going to get into others because my colleague has already said about the other issues. But no witness can dictate to us like what Paul O'Sullivan wanted us to do. We cannot allow that, Chair. That cannot be allowed. In fact, let's not even entertain it at all. It's like they wrote a love letter once again. Thank you, Chair.
DA.
Thanks, Chair. Yeah, I don't know quite what to say. Chair, we may well be Parliament and we may have terms of reference. It doesn't mean that we operate outside the bounds of the law. It doesn't mean that we have unlimited rights. I haven't had sufficient time to apply my mind to this letter, really, and to the contents. And I agree that witnesses shouldn't be able to dictate what they get questions on or not. But there is a question of legality here that we do need to consider, but I would need more time to apply my mind to that particular issue. So, yeah, I will go with the legal advice. Thanks, Chair.
Honorable Sols.
Yeah, this is a bit of a tricky one, I think. Obviously, I'm just a normal MP, and this is just an opinion which the legal team can provide more accurate guidance on. To me, it seems like a clash now between what protects us, which is the Privilege Powers and Immunities Act, against the Criminal Procedure Act that Ms. Trent's attorney is using. And we then need to decide on that dilemma. My first issue is number one, does this letter then imply that the WhatsApp messages that was read into the record is the letter indirectly saying that Ms. Trent is saying that it is indeed messages from her phone? That's number one. Number two, was the phone actually stolen or illegally obtained? This happened 9 years ago. The case was struck off the roll. There is no actual legal surety. There's no actual verdict in a court of law that says that the phone was stolen and or it was illegally obtained. And to steal something is a criminal offense. So it's a crime. So it has to be, the onus is on the person who alleges a crime has been committed to prove this beyond reasonable doubt. And as the committee sits here, we don't know beyond reasonable doubt whether this phone has been stolen, as it is said, or illegally obtained. And the attorney has to make that clear to us so that we then know, based on a court of law, the information that's read on the record is a fruit from a poisonous tree, as the attorney says. So I think from outside as the committee, in our oversight role, the second part of the messages has been given as part of the testimony of General Paslane, and he stated under oath that he's not lying to the committee. So that information was not received by the committee through illegal means. We, in good faith, believe that the general has obtained that information legally. Of course, outstanding now, we will hear from Honorable James whether she can also confirm that she has obtained the information she produced through legal means. I feel once both that is satisfied, that Honorable James got it through legal means, we assume that based on the fact that General Paslane has said so under oath that he also received it or acquired it legally, then that satisfies that what is on the record before the committee has been acquired legally. And so if need be that we have to question on issues around that WhatsApps that relates to the terms, our terms of reference, we should be able to do so.